So, good evening, everyone. I, on behalf of Into Legal World, welcome you all to our webinar yet again on understanding the competition law regime in India, wherein we'll be discussing the Competition Act of 2002 vividly. So, I am Advocate Anvesha
So good
Ghosh,
evening,
practicing at
everyone.
Jamnagar
I, on behalf
under
of
VH
Into
Kannada
Legal World,
Advocates and
welcome you all
Associates.
to our webinar
I'll be your
yet again.
moderator for today's session. I have completed my LL.M from National Law University, Ranchi, and my LLB from Vidyasagar University under Haldia Law College. So I have been the fortunate enough to be a gold medalist in both the LLB and LLM, and also have written a book on corporate scams. So before proceeding further, we'll talk about the forum that has brought the webinar today. So it's Into Legal World, a trademark of Parivritt Enterprises Private Limited, which is an established name in the legal fraternity. Into Legal World is a platform connecting the entire legal fraternity with its various wings, such as online news portal, publication house, legal services. Into Legal World Institute is now looking forward to launch its own application, which is Into Legal World application, which you'll find it very soon. We at Into Legal World have been serving our legal fraternity by providing quality legal contents in the form of legal articles, legal notes, lecture notes, legal news bites, and many more since 2016. With an aim to provide advanced and specific knowledge, the organization is devoted to research and innovation in law through their certification program on professional subjects as well as PCSJ special subjects, in which the faculties are honorable judges, eminent professors from NLUs, and well renowned advocates and academicians, thus providing an environment for transferring law aspirants into legal professionals. The institute is DIPP, central government body, and ISO certified. Under Publication House, registered as Into Legal World Publication, we have 55 plus publications to our credit and a channel of around 1,300 advocates to provide entire range of legal services. We also have a monthly magazine called Into Legal World Magazine, which is a compilation of briefs on important judgment from High Court and Supreme Court of each month as required for PCSJ preparation and for advocacy, along with articles and legal updates on various topics, for which you have to visit our website www.intolegalworld.com. Founded by Mr. Amresh Patel and Ms. Richa Shukla at a very young age, I'm glad to share that Into Legal World has been recognized as first legal startup of UP under Startup India program. And today we are mentoring more than 10 startups under us. So, without further delay, I'll be just introducing our speakers today. We have on board two speakers, that is Mr. Ankit Srivastava and Ms. Rhea Srivastava. So, Mr. Ankit Srivastava is currently working as an assistant professor in the Faculty of Law at Dharmashastra National Law University, Jabalpur. Before joining DNLU Jabalpur, he has worked as an assistant professor at National Law University, Jodhpur and Amity University, Lucknow, and holds a teaching experience of over 4 years. He is also pursuing PhD in the area of competition law from NLU Jodhpur. He has completed his Masters of Laws in Competition Law from NLU Delhi and graduation from Symbiosis Law School, Noida. He is also the director of Center for Research in Competition Law and Policy at DNLU Jabalpur. He has always been an active facilitator and coordinator of various committees before this. He has numerous paper publications in reputed journals to his credit and has also presented his papers in different national and international conferences. He has also edited a book called An Introspection into Corporate Criminal Liability in India, which I'm very happy to announce that it's been written by me and Sir has edited the book. He has also chaired various national legal events, ADR competitions, moot court competitions, etc. His area of interest is competition law, corporate law, RM, law of torts, and contract law. And Ms. Rhea Srivastava is a 2016 law graduate of Symbiosis Law School, Noida. After having interned extensively in the field of competition law, she decided to specialize in this area of practice and join the competition law team of AZB and Partners. After having worked at AZB for over 2 years, she joined the competition team of P&L offices. In 2019, Rhea went back to school to pursue her Master's in Law from the University of Chicago Law School. While pursuing her LL.M degree, she was a research assistant to Professor Randall Picker, an eminent antitrust professor. She is to join the antitrust team of Winston and Strawn, New York this year. So before we move further to our webinar and let sir and ma'am speak, I would just request the audience to kindly put your questions which you have, which you want us to answer in the live chat of this YouTube video towards the end of the session. So without further delay, we should start the webinar. Over to you, sir and ma'am.
Thank you so much, Anvesha. Thank you so much for a lovely introduction. And I would also like to congratulate Into Legal World to create such a platform for the students in such a time of pandemic, so that we can discuss on various issues relating to law and other subjects. Also, I would like to give my greetings to a very dear friend, Miss Rhea Srivastava. And I am very hopeful that her insights in this subject will help you learn about the nitty-gritties of the subject much more. So without further delay, I would like to first of all brief that what all we will be discussing in this session. In this session, we'll be starting with the concept of what is competition law and why is market very important with respect to it. So I'll first of all introduce you with the term market and the types of market and how competition law fits in one kind of market, which I'll be telling you. Then we'll be discussing from where this law began, that is the MRTP Act, and how from the Monopolies Restrictive Trade Practices Act, we moved to the Competition Act 2002. As I say, Competition Act 2002, the act was drafted and enforced in the year 2002, but due to certain issues, the Act actually got enforced in the year 2009. We'll also be discussing the reasons behind this. So, and after that, after discussing everything with respect to the coming of the Act, then we'll be discussing the major aspects of this Act, the major limbs, that are the three limbs which I called as Section 3, Section 4, 5, and 6 of this Act. And then we'll be trying to conclude by telling you how the CCI functions. So this is the brief outline of what we have taken as topics today. I have taken a very general and an introductory topic to competition law, because I feel that a lot of students might not have read competition law earlier. So we wanted to keep this session very interactive in the sense that we can discuss the things relating to, which can be helpful for the students who have never studied competition law. So from the very basic, if I say, or if I talk about competition law, then competition law is a very new subject in India, in Indian scenario, if we see. Because in the US or in the EU, if we see this law subject is almost 100 years old. So they have really, advanced in this subject. Our Real Competition Act, which I say, was enacted in the year 2002 and enforced in the year 2009. So it's been only a decade in which we are discussing this subject. So this is a very nascent, a very new area for everybody to understand. Also, now when we talk about competition or competition law, so the competition which we are talking about this competition with respect to the market. The market players, the market firms which are functioning in the market are the major players which are governed through Competition Act. Now, first of all, starting from the very basic, that what is a market? As we all know, market as a layman language, if we see what is a market, market is a place where a buyer and a seller meet and they interact, and the buyer purchases something from the seller. This is what the market is in a very simple language. Now, there are different types of market which we need to understand to start understanding the concept of competition law. So when we talk about different types of market, the 4 different types of market which I generally discuss when starting competition law, competition or the Competition Act, is the perfect market. The commerce students must be very familiar with these concepts. So it is perfect market, monopolistic market, oligopoly market and monopoly market. Now, coming to in detail aspects of these markets. So I'll start from perfect market and I'll move towards monopolistic, then oligopoly, and then monopoly. This is the way we move. Now, why am I starting with perfect market? Because perfect market doesn't exist. Okay, perfect market doesn't exist. Why am I saying so? Perfect market is an ideal situation where we want to reach the level of competition in the market. Okay, that is the level of competition which we are thriving for in the market. So we start with perfect competition. Perfect competition is something in which it is an ideal market situation now, that the seller is selling the product at the same price, which is the production price of the product. So he's selling the product at the same price. There are a lot of buyers and a lot of sellers. So there is no shortage of any goods, or there is no shortage of any goods. So there is no increase of price. So again, you have homogeneity in the product. You will get any product at any place. So there is no competition in the market because of the number of players available for you to choose from rather. So the Competition Act targets the benefit of the consumer as well as the other players of the market, which are there subsiding in the market. Now, perfect competition is a condition in which there is no profit-making intention of the seller or no profit-making intention even of the buyer. So the price at which the seller is selling the product, the buyer is accepting that price and purchasing it. So this is not the general condition which we are familiar of the market at this point of time. Correct? So when we go into the market, we also ask for, reducing the prices, or we ask for some offers, or we avail certain offers given by the companies in the market. So basically, we want to move towards perfect competition or perfect market, but that is an ideal situation, as I told you. Very close to perfect competition is the monopolistic market, monopolistic competition. Monopolistic market is a market in which, again, there are a lot of sellers and a lot of buyers of the same product. For example, a monopolistic market can be a market of pen. If I tell you that I want a 5 rupee black ball pen, so how many companies are there selling 5 rupee black ball pen? Can you count on fingers? Yes, you may count on fingers, but the number is huge. The number is huge. Now, even if one company out of it, or 2 company, 3 company out of it collude, come together and decide that they will not sell this pen for 5 rupees, but for 6 rupees. So even that will not affect us as consumers in the market. So, even if they come and collude together, that will obviously not affect us, because we have 70 other companies to choose from for a 5 rupee market pen. So there is no impact of the agreement, any agreement, if those companies are trying to indulge into an anti-competitive agreement, there is no impact on the buyer. So this market again is very close to perfect market, but it is not exactly perfect market. So this market has very less, or you can say no relation to the competition issues as such. Then comes the major aspect of the major market which is to be looked upon is the oligopoly market. The oligopoly market is a kind of market which has very few number of players. Now, when you say that they have very few number of players, then it means that, for example, if we see an example, let's see the example of airline industry. Now, how many airlines do you see? Airline industry flying domestically. So we have 5 or 6, I think, airline industry which fly domestically. All of them are giving the same services. So the problem is, in oligopoly market, the number of players are few. They are providing same services. Okay, same level of service. Homogeneous services is provided. So the competition among them is very much. Why? Because all of them are providing the same. All of them are making, giving us the availability to travel from one place to the other place. So, and generally, if you see the airline industry, everything is same with respect to shifting of cargo or passengers, etc. The nature of business is homogeneous, and there are fewer number of companies. So in this kind of market, there is much more higher chances of them coming and colluding with each other and forming anti-competitive agreements. And if they form the anti-competitive agreements in this kind of market, let's suppose there are 5 to 6 domestic flying airlines and 4 of them come and collude together, then what will be the options we'll have as a consumer? Although we'll see 6 players in the market, but actually how many players are there in the market now left? 3. So that will reduce the competition in the market, and that will at the end affect whom? The consumer. Now let's suppose those 4 airlines collude and fix a price which is higher than the prices of the other airlines, but they provide good services and they provide flying on certain routes which are not available on the other airlines. So if they collude and they charge us even at a higher price, 15,000, 20,000, we have no option but to travel. But to prove cartel is a bit technical, and circumstantial evidence is relied upon in this scenario. The DG investigates and all that will come to later. But the thing which I'm trying to explain you, that the oligopoly market is the most susceptible market when it comes to the competition law issues. It is the most targeted market because the number of players are few, they are dealing in the same kind of services, and they, rather than competing, they want to collude, because they say that they are not the competitors amongst themselves, but they are the actual competitors of the consumers. So if they collude, then they are not the enemies of each other, but the actual enemies are the consumers. So if they collude, they can share the profits, profits of the anti-competitive agreement they are entering into, and the consumers will ultimately suffer. So this kind of market is again susceptible to competition law issues. The last one is the monopoly market. The example of monopoly market can be Indian Railways. If you see, now Indian Railways is the only mode of rail transportation which is available to you. Now, whatever prices or whatever services they are providing, whatever prices they are fixing, or whatever they are lacking, we cannot do anything about it if we want to travel by train. So monopoly, that is why the competition is against monopoly. Now, why it is against monopoly? Think about it. If there is a company which is only one company in the market, which is there, and then there is a market in which there are many companies to choose from, which is better for you? Any day, the company, the product for which there are many companies in the market is a better market for you. Why? Because you will have choices. For railways, if I see as an example, railways. Now, if railways is not providing you with a good service, or the trains are late, the price hikes and everything, you don't have any other thing to compare it with if you talk about rail transportation. So you'll have to choose that option if you want to travel by rail. So that is why we always say that moving towards monopoly is harmful for competition. Perfect competition, monopolistic competition, good for competition, excellent. Moving towards monopoly, coming to oligopoly, huge disrupted market when it comes to competition, and monopoly, again a very susceptible market when it comes to competition. No, the company Ambassador and Fiat. So when we talk about Ambassador and Fiat, these were the two companies which were there in the Indian market, Indian car market till the year 96, 97, I guess, after which Maruti came into the picture. And within 5 to 7 years of coming of Maruti into the picture, the companies Ambassador and Fiat were almost out of the market. Ambassadors were still in the market because of the government officials traveling in it, but Fiat was mostly out of the market. Why? Because when a company is in a monopoly, they were that at that point of time they were in a kind of monopoly or duopoly. Now, when there is a monopoly in the market, the companies don't tend to invest in the research and development. When Maruti came in, the new technology came in the market. The new technology came in the market, which was much more liked by the consumers, which was less maintenance. They were paying less maintenance cost, and they were getting a lot more options in that price only, which the Fiat and Ambassador were not giving. And the Fiat and Ambassador at that point of time also did not start to put money in their research and development. Hence, that was the reason they were kicked out of the market. And see the importance of competition, that even one company or coming of two companies, when there were already two Indian companies in the market, those two Indian companies were kicked out of the market because they were not doing any research and development. So this is the benefit of competition, that when there is competition in the market, you will see that the companies are trying to put more and more for the consumer welfare or consumer benefits, and they'll give more and more options to the consumer to choose from. So the more options you have to choose from, the better for you. So this was a concept of how the market functions and what are the types of market in which there is competition issue. Now coming to, when did competition law or competition as an aspect became important in the Indian markets? So the Competition Act came in the year 2002. It was enacted in the year 2002, but enforced in the year 2009. Now again, before the Competition Act of 2002, there was one Monopolies Restrictive Trade Practices Act of 1969, which was formed, which was enacted. Why? Because there were few companies in India which were having dominant position, which were rising at a very great pace, and to curb that, the government thought of setting up a committee so that it can stop such companies from becoming a monopoly and affecting the competition in the market. But the act was very weak in the sense, as we all know, that in 1991 LPG reforms happened. The liberalization, globalization, privatization reforms happened. And after that, the foreign investors were allowed to come in. Now, the MRTP Act was not that strong to handle the terms and conditions with respect to the foreign investors when it came to competition. They could only, if they see that a company is going towards monopoly or is rising in the market apart from the other companies, they could only cease and desist. They had the power to order a cease and desist order for that company. Even that was not followed by the companies even after the passing of that by the Monopolistic Restrictive Trade Practices Commission. So the Competition Act was very important to be established because of the lacunas in the law which was there in the MRTP Act. Because MRTP Act was not strong enough to hold or to hold responsible the companies for anti-competitive activities. Also, the MRTP Act only talked about dominance and not talked about the different issues with respect to combinations and anti-competitive agreements, etc. So there was a need for a new act, and a Raghavan committee was established by the government. On the recommendations of the Raghavan committee, the Competition Act 2002 was enacted. Now, the Competition Act 2000. Now, coming to the Competition Act 2002, I think that you might not be having the bare act of Competition Act, but if you can open it on your devices, on a page, the Competition Act 2002, the first link will be of CCI. That is the authentic bare act of Competition Act. So if you can open it, it will be good for you to understand. Now, coming further, when we talk about Competition Act, 2002. Yes. Okay. So again, the next point was that the Competition Act was enacted in the year 2002, but enforced in which year? I told you it was enforced in the year 2009. Now, it was when enacted in the year 2002. Why was it enforced in 2009? There was a 7-year lapse in the enforcement of the act. Why? Because when the CCI was formed, when the government, according to the Competition Act 2002, the central government had to make rules for the appointment of the chairperson and the other members of the Competition Commission of India. So there was a person named Brahm Dutt. He filed a case saying that the Competition Commission of India the Brahm Dutt filed a case challenging Rule 3 of CCI selection of chairperson and other members of the Commission Rules 2003. He challenged Rule 3 of this. What did Rule 3 say? Rule 3 says that the central government was to constitute a committee consisting of persons who has been a retired judge of Supreme Court or High Court, or a retired chairperson of a tribunal, or any person with a special knowledge and professional experience of 25 years or more in the areas of economics, in the areas of business, international trade, commerce and industry, accounting, etc. Now, what did Brahm Dutt say? Brahm Dutt said that if CCI is a judicial body, it is a judicial body because it will pass orders with respect to Competition Act. So if it is a judicial body, it should be presided by a judge or the Chief Justice of India. Now, again, when this was filed in the court, then he said that the Rule 3 of the Act, with rules I told you, the Rule 3 should be struck down. And the reason he gave was the commission was more of a judicial body having adjudicatory powers, and chairperson had to be a person connected with the judiciary picked up by the Chief Justice of India. This was his contention. Now, the Union of India also, he filed a case against Union of India. So Union of India gave their contention saying that commission is not a judicial is not a judicial body but a regulatory body. It will regulate the competition in the market and it will have quasi-judicial functions. So for that, because it is a sector-specific act and a sector-specific commission of competition related to market, so we need specialized people in the area. So the government said that commission was more of a regulatory body and thus requires expertise in the field which cannot be supplied by the members of the judiciary at time. It was there. So as long as the power of judicial, now the government also said that the power of judicial review will always be there with the court. If the CCI is not, is not appointing the correct person to the CCI, if the government is not appointing it, then it can obviously be challenged as the court has the power to judicial review. Now, so this was the argument of the Union of India. The case was still going on in the court. Before the case could end in the Supreme Court of India, the government itself came up with 2 amendments which settled the situation. So the 2 amendments were, the government filed 2 affidavits proposing to make amendments to the Act and Rule 3 as to enable the chairman and members to be selected by a committee presided by the CJI. So the government allowed it, that through an affidavit, they gave the public notice that the members and the chairperson of the CCI will be appointed by the committee, which will be headed by the Chief Justice of India. After this, the issue was resolved and the Competition Act, which was enacted in the year 2002, was enforced in the year 2009. So I would want you all to go and read this judgment. It's a very interesting judgment. I think the fourth issue deals with this of the judgment. It is a very interesting judgment of Brahmdutt versus Union of India, year 2005 Supreme Court case. So you can go and read this case if you want. Now, this is the story behind the 7-year lapse of the Competition Act from 2002 to 2009. Now, in the year 2009, the Competition Act started functioning, and it's been 10 years that it is now functional, more than 10 years. They have passed 1 decade. Now, coming to the Act. What is the importance of the Act? What does the Act do? Is conveyed in the preamble itself. The preamble of the Act says that if you have the bare Act, it is very good. You can go to the preamble section and we can see together. The preamble says that an Act to provide, keeping in view of the economic development of the country. So this is very important. Economic development of the country, for the establishment of a commission. Now, the commission, that is the Competition Commission of India, to prevent practices having adverse effect on competition. To prevent such practices amongst whom? Amongst the firms in the market, the different players in the market, different companies which are there in the market, to prevent such practices by those firms which has an adverse effect to the competition. Okay, this was the first objective. Second objective was to promote and sustain competition in the market. So the Competition Act wanted to promote the competition and sustain competition in the market. MRTP was only there to curb the growing stature of a company. If a company is dominant, it was the MRTP would take an action against it. But the Competition Act never said that you cannot be dominant in the market. That will be dealing in section 4. Now, the second objective was to promote and sustain competition in the market. The third objective was to protect the interest of the consumers. Obviously, if the companies are colluding, if the companies are coming together, framing an agreement, coming into an anti-competitive agreement, then obviously the consumers will suffer. So, to protect the interest of the consumers by not allowing anti-competitive agreements or abuse of dominance. And the fourth objective, to ensure freedom of trade carried on by other participants in the market. So, the Competition Act 2002 doesn't only help, doesn't only protect the interest of the consumers, but also protect the interest of the other players in the market. If one company is abusing its dominant position, that means that it is not only harming the consumer or the consumer, but also the other players of the market. If there are 10 companies and 5 are coming into an anti-competitive agreement to fix prices, or we'll discuss in section 3, for any purpose, if they are coming for an anti-competitive agreement, which is against the competition regulations, then the other 5 companies are suffering from it also. Right? And the consumer is also suffering. So to prevent and protect the interest of the consumers as well as the other players of the market. So for this purpose, for these 4 objectives, the Competition Act 2002 stands. Now, coming to the major limbs of this act. Very important aspect of Competition Act. Competition Act majorly is in section 3, section 4, section 5 and 6. These are the 3 limbs, major limbs or the major heads, which I call is section 3, section 4, section 5 and 6. Section 3 talks about anti-competitive agreements, every aspect of anti-competitive agreement, be it horizontal, be it vertical. Section 4 talks about abuse of dominance. And section 5 talks about combinations, that is mergers and acquisitions. Now, coming to section 3. Section 3 is talking about anti-competitive agreements. Now, anti-competitive agreements, what do you mean by anti-competitive agreements? Any agreement formed between companies, between the players of the market, okay, any agreement which is formed between the players of the market controlling any aspect of the market with respect to purchase or sale prices, with respect to production, supply, any technical development, with respect to share the geographical area of the market, or with respect to any bid rigging. Now, when we talk about anti-competitive agreement, we are talking about Section 3 of the Act. So if you can come to Section 3 of the Act, we can see that anti-competitive agreement, we can see that when 3.1 says that no enterprise or association of enterprise or person or association of person shall enter into any agreement in respect of production, supply, distribution, storage, acquisition, or control of goods or provision of the services which causes or is likely to cause an appreciable adverse effect on the competition. Now, for example, if we see, there was a case of onion cartel case. Now, anti-competitive agreements was formed between the traders of the onion market. There was this allegation. It was not proved at the end in the case, but this was the allegation that you remember that the onion prices were, hiked, or it hikes every year at certain stage to 120 and 150 rupees a kg. So it was alleged that the trade association in Mumbai were coming into cartel. They were forming cartels and they were holding the product. Matlab, the amount of onion in the market was sufficient enough. But what did the traders do? Traders held the onions. Why? Because by holding it, the demand of the onions will rise. And when the demand of the onion will rise and there will be no stock, the prices of the onion will automatically rise. So this was the allegation, but due to lack of evidence, or there was no evidence in respect to this, it was not proved. But this can be a very good example to understand that how a cartel functions. Now, the trade association members, through a meeting or through anything, they can come together. They can decide amongst themselves that all of them, or whosoever are the major traders, will hold the product in the market. Will hold the product in the market till such a point that the price rises, and when the demand rises and the price rises, they'll release the product and they'll sell it at a higher price and divide the profits amongst themselves. So this is the concept of a cartel, which is formed under Section 3, which is defined under Section 3. I hope that this example is clear to you. Now, coming to the most important aspect of Section 3, that is Section 3.3. Now, when we talk about anti-competitive agreements, there are two types of anti-competitive agreements. One is horizontal and one is vertical. When we talk about horizontal agreements, or horizontal anti-competitive agreements, we are talking about the collusion or the cartel formation between the companies of same stature, as in the companies at the same level. For example, that if Maruti, Hyundai, Honda, Tata come and collude with each other, that will be a horizontal anti-competitive agreement. Why horizontal? Because all these companies I am talking about are car manufacturing companies. They are manufacturing cars and they are providing the same services and are homogeneous. So they will come at same level of market, correct? So when companies at same level of the market come together and collude and form a cartel, that is horizontal agreement. That is defined in Section 3.3. Now 3.3 says that any agreement entered into between enterprises or association of enterprises or person or association of person, or between any person or enterprise, or practice carried on or decision taken by any association of enterprises or associated of person, including cartels, engaged in identical or similar trade of product, provision of services. Now, these four conditions are very important. When we will say that it is an anti-competitive agreement, when these four conditions are fulfilled. The first condition is directly or indirectly determines the purchase or sale price. When the companies are coming together and they are determining the sale and purchase price of the product, okay, they are fixing it according to themselves that this will be the purchase price and this will be the sale price of a product. Then in both the scenarios, it can be an anti-competitive agreement, not only for sale, even for purchase. So the second point is limits or controls production, supply, markets, technical development, investment or provision of services. The example I gave you, the onion cartel example I gave you. So that is that they were limiting or controlling the supply of the product. So that can also be considered to be an anti-competitive agreement. C, shares the market. Now let's suppose that there are 4 telecom companies A, B, C, D, and they say that we'll divide the Indian geographical region into 4 parts: north, east, south, and west. And A will only function in north, B will only function in south, C will only function in east, and D will only function in west. Any profit which comes out in their area will be theirs, and rest other 3 will not interfere in the area of the 4th one. So by this, the 4 companies coming together, dividing their areas into different geographical areas, and then providing it, then doing the business. So this is also an anti-competitive agreement in which you are not allowing the other players to enter into the market in which you are functioning. So by dividing the geographical area also, it is an anti-competitive activity. The 4th one is directly or indirectly results in bid rigging or collusive bidding. Now when there is an auction, there is a bidding going on, and few of the players have already colluded earlier, or even there but at the spot, on the spot, if they collude, then also that will be called as an anti-competitive agreement. Now this was the horizontal agreement. Coming to the vertical agreement. Now I gave you the example of horizontal agreement as the example of different car brands which were at the same level, and those were colluding. So that was horizontally anti-competitive. Now coming to vertically anti-competitive, when we talk about vertical anti-competitive agreements, then let's suppose that a car company is having an agreement with an engine oil company that car company will only sell the engine oil of X brand and will not sell any other brand. Okay, and they are coming into an agreement, an agreement, so that company, the car owner, the consumer is not allowed to put any other engine oil in that car. Otherwise, the car company will not service the car. So in such a condition, there is a vertical agreement. Why vertical? Because there is a car manufacturing company and then there is an engine oil manufacturing company. So these two are at different levels in the market. So when the companies are at different levels in the market, then it will automatically be a vertical agreement between the two. Now, when there is even these types of agreements are known as anti-competitive agreements. So section 3 subclause 4 talks about anti-competitive agreement, says any agreement amongst enterprise or person at different stages or levels of production chain in different market in respect of production, supply, distribution, storage, sale or price, or trade in goods or provision of services, including 5 things: tie-in agreement, that they have tied with each other, and you don't have any other options to go for, and they have tied. So then that is an anti-competitive agreement. Exclusive supply agreement, that only this person will supply. So that is also anti-competitive. Exclusive distribution agreement, that is also anti-competitive. Refusal to deal, that you are refusing to deal because your terms and conditions were not fulfilled, so you have refused to deal with in that area. And then resale price maintenance, that you are fixing the price for the next person to sell that product further to the consumers, that you cannot sell this pen less than 50 rupees in the market. then only I'll give it to you for selling further. So that is also anti-competitive. So this was a very broad and very basic explanation of what Section 3 is all about. It is impossible for me to explain you in 15 minutes the nitty-gritties of Section 3. It is very essential for you to understand the basics and then go into it. Then go into the delve into the nitty gritties and the wider aspect of Section 3. Every line, every point of Section 3 can be one chapter in itself. So the Section 3 is very extensive when it comes to horizontal agreements and vertical agreements, and it requires a lot of reading, a lot of time, and a lot of aspects are related to it, which can be looked upon. So this was a very brief of what cartels, of what anti-competitive agreement at horizontal level was, and what anti-competitive agreement at vertical level was. Now, I would like to request my co-speaker, Miss Rhea, my very good friend, to further deliberate or elaborate upon the fact, whatever I have spoken. If I have missed something, you can add upon definitely, or and then go to Section 4 and explanation of Section 4 and Section 5 and 6. Thank you.
Thank you, Ankit, for setting out such important concepts and topics and setting out the stage for discussing topics such as abuse of dominance and merger control regime. Now, I would be continuing further and dealing with the second limb, which is abuse of dominance, and the third limb, which is the merger control regime. Now, coming to the abuse of dominance. In order for an entity to survive in the market, for any enterprise to survive in the market, it is important for it to compete in a level playing field. Now, in reality, as Ankit discussed, we have an imperfect market, and therefore we have the CCI in India, as well as other competition regulators in each jurisdiction to prohibit monopolization and abuse of dominance. Now, it's very important to understand that the philosophy of abuse of dominance per se is a situation of monopoly which is exercised by an enterprise and is not against the public policy, but it's rather the use of such monopoly status that it operates to the detriment of the competitors and customers in the market. Now, I've been using the term abuse of dominance. What is dominance? Now, when an enterprise has a monopoly status in the market, as been elucidated by Ankit, it's usually called as a dominant enterprise. However, you don't have to only be a dominant, you don't only have to have a monopoly status. You can have sufficient market share. If you have even 2 players or 3 players in the market, but if you have a certain market share, or there are certain factors which you tick off as per CCI, you may be considered a dominant enterprise. Now, such an enterprise may freely adopt any price, any unfair condition. It can act independently of market forces. I'm using the term market forces here. What are these market forces? If I, as a company, have a dominant position in a market and I'm able to act independently of such forces, these forces which act against me are what? Customers, suppliers, competitors. My competitors exert a certain force on me because of which I'm not acting in an arbitrary position in the market. My customers, my competitors, my suppliers, my distributors, they all exert some sort of force on an enterprise which is operating in that market, right? Now, in order to assess, now I can give you an example for that actually before coming to the 3-prong test under abuse of dominance. If you have only one company right now in my sector, which provides disinfectant services in my area, right? It's one of the only companies which is doing it. It can charge any price it wants. It can charge any condition it wants. It can say, in order for me to disinfect your house, you also have to buy these certain things from me, So this is the kind of activity which is prohibited under the law. Now, in order to assess whether any entity has abused its dominant position in the market, there are primarily 3 stages. The first stage is to define what the market is. When I'm saying market means the relevant market. Now, the first stage is defining this relevant market, which is the combination of your relevant product market and relevant geographic market. Now, a relevant product market would comprise all the products and services that are substitutable or are interchangeable. For example, as a customer, if I go to the supermarket, for me, a real juice and a Tropicana and the Nimbus would be substitutes and would constitute one market. A Samsung phone, a OnePlus, a Huawei would all constitute one product market. For me, Amazon and Flipkart, because I can find pretty much the same things on both the platforms, would be considered one market. The CCI also, while considering, it has to define the product market, right? It has to consider certain factors. It can't take an arbitrary decision. So it considers factors such as the end use of goods, the physical characteristics of the goods, the utility of the goods, the price of the goods, the consumer preferences. Price is also very important. For me, if I want something in the price range of 100 to 200, I will not buy that product. For me, a 1,000 rupee product will not be the same as a 200 rupee product, right? So that's very important. My preferences are very important. What do I as a consumer consider substitutable? The second prong of the relevant market is the relevant geographic market. Now, when I have decided that this, for me, Amazon and Flipkart are one market, but in which area is it in that one market? The second prong is the relevant geographic market. Now, the relevant geographic market, if you see, is defined under the Act. You go under, if you open the Act, you have section 19. But very simply put, the relevant geographic market would be an area in which the conditions of the competition that apply to those products and services are the same, right? For me, if two companies that are providing disinfectant services only in my sector, that would be one market, right? It would be, for example, a company that manufactures cement. The region where it sells cement might be considered one geographic area because it may sell cement only to that area because of high transportation cost. Now, there can be several geographic areas that can be limited to only a few sectors. It can be limited to only Delhi NCR, North India, South India, few states, Delhi, Punjab, Haryana, few states of where the products and services are provided. It can be even be pan-India. For example, services like Paytm, PhonePe. If I'm assuming hypothetically they are available in all states in India, the relevant market would be pan-India, right? Now, while determining, again, there were certain factors which the CCI would consider while delineating the relevant product market. There are certain factors while the CCI will consider while even delineating the relevant geographic market, right? These factors would be, factors such as trade barriers, transportation costs, local specification, language, also consumer preferences. So for me, something which I will not probably buy something which is in Gujarat. For me, that does not constitute a relevant product market as a consumer, of course. So it's the combination of a relevant product market and relevant geographic market constitutes the relevant market. Now, the relevant market is the first thing that you assess. If somebody comes to you with an abuse of dominance problem or states that this company is acting unfairly, what do you first do? You say that which is the market it's operating and this is the market, right? The second step in the assessment of whether an enterprise has abused its dominant position is to consider the degree of market power or monopoly power in that defined relevant market. Now, while assessing whether an entity is dominant, the CCI will consider several factors such as vertical and horizontal overlaps in the market, right? It will consider market share of the enterprise. It will consider the size and resources of the enterprise. Market share in the sense, if I'm operating in the market of Delhi and I am supplying books, like I'm a store which supplies books, what is my market share of the total stores that are supplying books, right? Assuming I'm taking, only offline bookstores into consideration. What is the market share of my competitors that are supplying books in Delhi NCR, right? Jio, Vodafone, Airtel, is one market. You will, while assessing a dominance of Jio, I will look at, this is my denominator, this is my market, total market, and this is how much Jio has or Vodafone has or Airtel has. Same, for example, phone manufacturing companies, Apple, Samsung, OnePlus, right? The CCI will also assess the economic power of the enterprise. Am as a consumer or a supplier, am I dependent on this company? Are they providing me any specialized goods or products? These are questions that the CCI looks at while assessing whether you have market power in that relevant market, right? Now, I mentioned market share. It's a very economic term and a very economic analysis of how market share is, how the market share test actually takes place. But one question that's often asked is there a bright line market share test above which an entity will for sure be considered dominant? It's very important to note that the CCI has recognized that market share is one of the factors. I listed out several factors. Usually people always have this question: if I have 30% market share, 20% market share, 40% market share, will I be considered dominant? Straight up. Now, while determining a monopoly power, not a monopoly power, or dominant power in that relevant market, the CCI looks at market share, but it also looks at other factors, right? It looks at how fragmented the market is. Do you have small players in the market? Do you have other large players in the market? So that. Very interestingly, in a case which was filed very recently against WhatsApp, I think last year, in order to determine the dominance of WhatsApp, how do you determine the dominance of WhatsApp in the market? For instant messaging services through consumer communication appliances, that's the definition of product market, the CCI relied on the number of active users in India and the number of installations in India. It's a very interesting way on how to define the market. Again, I told you about the market share, bright line market share test. Recently, again, there was a case filed against Ola and Uber in relation to price fixing. The CCI did not find them to be a dominant player in the specific cities that they operate in, despite the fact that the market shares were as high as 40%, 50%. The CCI analyzed the market and then said that, you can have a high market share, but because it's such a high-tech industry, it's also prone to high market fluctuations. And because of these high market fluctuations, even though you have a market share as high as 40, 50%, you're still not considered dominant. Now, the second thing, very important thing to note, that if I'm a dominant player, is that bad? Because the goal of every company is to maximize profits, is to enhance their market share in the market. But so if I'm doing that as a company, every enterprise, that's their goal. That's their end goal. The answer is no. Because you can have a first mover advantage. You could be doing so well and so much better than your competitors. That can't make you liable under the Act. However, under the law, when you do occupy a position of dominance in the specific relevant market, you do have a special responsibility to other players to not distort competition. If the CCI decides that I'm a dominant player, I do have responsibility to my other customers, suppliers, players, other other players in the industry to not harm competition in the market. There has to be a level playing field. Another thing to note is that if it has been decided that there is no dominance, there's absence of dominance, there can be no abuse. I don't need to go into my third step, right? If I'm not dominant, that being that, that's where I stop. I don't go down to the next step. Now, the third step, which I'm talking about, is determining whether the enterprise is in a dominant position and has some act or conduct which is specifically prohibited by the law. Now, whether the enterprise or the entity which is involved has it engaged in, now you see section 4, if you have the Act open, it says section 4(2)(a) gives certain, there's certain conduct which is prohibited. Simply speaking, what all can a dominant enterprise not do? Or what, if it does, will be scrutinized by the CCI? Unfair purchase or selling price or conditions. This includes predatory pricing. What is predatory pricing? It's pricing below cost. It's basically that as a company, I can make losses then I sell something which is below cost, make a loss, push out all the other competitors, and then hike my prices for the customers. Not allowed. I limit production. I restrict production. I'm denying market access to other players. I don't let other players enter the market. There's hindrance in acceptance of contracts, and I make that if you have to enter into a contract with me, that's subject to other obligations which are probably not related to the purpose for what my contract is for. It's unconnected. Also, the fifth thing is leveraging. Leveraging is using my market. If I operate in two separate markets, or I want to enter into another market, I use my position in one market where I'm dominant, market A, to enter into or protect another relevant market, market B. For example, I have a company which manufactures alcohol as well as juices and holds a position of dominance in the market of alcoholic beverages. Now, anybody who wants to purchase a bottle of vodka of that company would also have to purchase juices from that company, because the market of juices which it's currently in, it does not currently hold a very high market position and wants to expand, right? Now, one thing to note is that if you do engage in any abuse of dominant activities, as I just mentioned, and you do not have a justification for doing so, in that case, the CCI is going to come after you. You have to have, if you do have a rational or economic justification, which you do have to provide to the CCI, in the absence of that, the CCI will penalize you. What are these penalties? It can direct you to discontinue from the abuse. It can impose penalties on you. These penalties range up to like 10% of the average turnover last preceding 3 financial years. So it's important to understand that these penalties, this analysis, conducting an abuse of dominant assessment is not to discourage companies from making profits, from doing well in their businesses, because that's the main objective of a business. It's to grow. It's in place so that once you achieve that position in the market, you can't make it hard for other competitors, other market players to operate in the market. So it's for regulation of the market, which is very, very important, especially if you have players who hold dominance in that market, right? So that's the basic premise, basic objective of Section 4, which is the second limb of behavioral law, right? Coming to the third limb of substantive part of competition law, which is merger control. It's Section 5 and 6. Now, I would like you to open, actually, if you can, Section 5 and 6. Won't be referring to it a lot, but it's nice to have it because it lays down certain tests, actually. Now, enterprises enter into mergers, acquisitions, amalgamations. I will be referring to all three as combinations to increase the competitiveness of the industry. However, these combinations can have a negative effect on the competition in the market. It's therefore the government controls these combinations within the country to promote competition, to see that there are small-scale establishments are not overshadowed. If they want to enter the market, and you have entities which are merging and acquiring them or amalgamating, entering into these transactions, they shouldn't be overshadowed. They can't be swallowed by big industries. It's because the merger of big companies reduces competition and makes it difficult and almost impossible for smaller firms to grow or profit. This leads to major policy issues, and therefore the CCI says, I'm going to intervene. The merger control provision, Section 5 and 6, allow the government of India through the CCI to intervene, and in the wider scope of either stopping such mergers or such harmful mergers or acquisitions, or telling them that these are the certain modifications that you may make. Now, before I get into the aspects of Section 5 and 6, I want to very, very briefly touch upon what are the combinations and what are from the most problematic to the least problematic. Most problematic are horizontal combinations, basically combinations which refer to the combination of firms in the same that produce the same or similar type of products, engaged in the similar process of production, manufacturing, distribution. mills, two companies, two textile mills, two cement manufacturers, Ambuja and Ultratech companies, right? They will be, if they start to merge, then that will be one horizontal combination. These combinations can be problematic as it increases the market share of the combined entity, right? There's the incremental market share. If I as Ambuja Cement have 20% hypothetically, and Ultratech has 20%, combined I have 40%. Hypothetical numbers. Then the second type of combinations, which are a little less problematic, are vertical combinations. Vertical combinations are combinations of different firms engaged in different processes. Company A manufactures handbags, company B supplies the leather that is used to manufacture these handbags. They merge, different production chains. If they merge, that's a vertical combination. IKEA, the furniture giant, because one of the raw materials that it uses extensively is wood, it got forests. That was a vertical combination. A merger between an online shopping website and Paytm would be, or a PayU or a payment gateway provider would be a vertical combination. However, there are certain mergers that come under legal scrutiny because the one entity ends up controlling raw materials or the downward distribution of production chain and may end up killing competition, right? If I, as a manufacturer of handbags, or I am acquiring a company that supplies the leather, I won't buy from other companies which supply leather because I have my own, right? So that can kill competition, but there are, of course, justifications that may be provided. And if the advantages outweigh the costs, then it's great. The third type and the least problematic would be a conglomerate merger, which is basically merger between firms that are involved in totally unrelated activities, right? Leather company, perfume company, like doesn't matter. They don't overlap anyhow, right? So these are the certain types of combinations that take place broadly. Now, every transaction that takes place does not need to be notified. You don't need to go to the CCI with every combination or every transaction that's taking place right now. A combination will only be scrutinized under the Competition Act if there are certain tests and thresholds which pertain to asset and turnover mentioned in the Act, if they are breached. If you look at Section 5, there are certain tests which are given. I'm not going to get into each test because this is a party test, it's a group test. There's certain tests for India as well as, worldwide tests. So there are 8 tests under Section 5. If any of these 8 tests are met, you need to notify. However, the CCI understands that, if you need to have certain exemptions, even for companies that are being acquired, right? Or merged. So there are 2 major kinds of exemptions provided. First, it's called the target-based exemption or the de minimis exemption, which is essentially, it's not in the Act, it's by the notification provided by the Ministry of Corporate Affairs. And it's on the CCI website, of course, if you want to have a look at it. It says that a transaction will be exempt from notification if the assets or turnover of the enterprise being acquired does not exceed 350 crores in assets or 1,000 crores in turnover. Now, this is an or and not an and. So you can be less than 350 in assets and more than 1,000 in turnover and still qualify, and you don't need to notify the CCI of your transaction. You're exempt. The second type of exemptions are under Schedule 1 of the Combination Regulations. This is the Act. You have a combination regulations which govern combinations. So Schedule 1 of that, it specifies certain categories of transactions that are not going to have an effect on competition and therefore are not required to be notified to the CCI. These include like minority investments. I'm making a 2% investment, or I'm making an investment in an unrelated company, or my investment is solely as an investment. It's made in the ordinary course of my business. However, all of this is caveated by that this should not lead to acquisition of control. Control is defined under the Act, but very simply, it means controlling the management of affairs of an enterprise. It means if I have a right to nominate a director on the board of directors, if I have affirmative voting rights, right to change or amend the memorandum of association, articles of association, if I can appoint or remove key managerial personnel like the CEO, CFO, if I have a veto right like this, I can be deemed to be controlled. And now, once we've determined that this is a transaction which does not fall under any of the exemptions and needs to be notified to the CCI, what do? You have to file. When do you file? Now, in case of acquisitions, after you've executed a binding transaction document or there is a agreement or decision to acquire control, you file on the basis of that document. In case of mergers, it can be the approval by the combination of the board of directors of the parties. And what is the timing of filing notification? Currently, as of the law stands today, transactions must be notified before completed. Also, very interestingly, in July 2018, the CCI introduced an online do-it-yourself kit. You can look at that kit, you can analyze, it's online actually, and you can analyze whether your transaction should be notified or not notified. It helps stakeholders to assess the notifiability. I think it's very helpful, and it's something the CCI is moving ahead of its times. Now, once you have submitted this notification to the CCI, there is a review process the CCI will do. It will look at the transaction, the combination, and will assess the likely competitive effects of the combination. The first step is identification of the relevant market. We've already discussed that. The second step is whether in that relevant market, the combination will have any appreciable adverse effect on competition. It's usually in competition terminology, we call this AEC. This will be assessed. There are several factors through which the CCI will assess this. Some of them being what's the incremental market share. If two entities are combining, what would be their incremental market share in that relevant market? Are there any potential competitors in the market? Is there competition through imports? Like if it's a vertical arrangement and I've acquired a raw material source, is there raw material being sourced through imports? That can also pose as competition in the market, which is great. Am I removing competitors in the market? Because of this transaction, can new firms enter the market? Are there high entry barriers? Do you have to have substantial investment to enter the market? Is it easy to enter the market? Now, the CCI looks at these factors and comes to a determination of whether such a combination will or will not, have an adverse effect on competition. It has 30 days to do so, 30 working days to do so. After this review process is over, the CCI will do three things. It will either approve the combination, it will direct that the combination does not take place. Now, usually, to the best of my knowledge, the CCI has never directed a combination to never take place. The third thing that it may do is that it can suggest modifications. It can say that, don't acquire, if you're acquiring 6 companies, don't acquire 3 of these. It can suggest suitable modifications. If the parties that are entering into the combinations feel that there is some certain pushback, they can also suggest modifications, to assist the CCI to come to a decision and approve the combination. Now, the very important question is, why is all of this done before completion? This is done because it's very difficult. You can't unscramble eggs. Therefore, you can't unscramble a transaction once it's been completed. Once you have completed a transaction, you can't go back. Then if the CCI thinks that there is a problem with the transactions, it's very difficult if 2 companies have merged, shared their know-how, got into the transaction process, had that sort of substantial cost in that transaction. It's very difficult to unscramble the entire transaction. And I feel that's one reason why the CCI wants to look at the transaction, approve it, and then see what the impact is on the market. The corporate law, company law, all of this deals with the procedural aspect of this is how the transaction will take place. CCI, the Competition Act and the CCI will look at the effect of a combination in the market. It's to enhance consumer welfare. It's to enhance competitiveness in the market. It's so that there is a level playing field for everybody to enter the market and have and be competitive and there shouldn't be any unfair conditions. So I feel that abusive dominance, as well as merger control regime, are there for that reason, and that's exactly why these three things are considered the three most important substantive limbs of the Indian Competition Act, as well as other competition regimes in the world. So, Anvesha, if we have any questions.
So yes, hi. We have a lot of questions currently. So would you want to take them one by one?
Yes.
Yeah.
Sure.
The first question, we do not know the name, but what are the functions of Competition Commission of India? I am sure you both have discussed the functions through the sections, but if you could brief them a little bit. The functions of Competition Commission of India.
Okay, so the functions of Competition Commission of India can be to eliminate practices having adverse effect on the competition, then to give opinion on competition issues, that is on consumer welfare, ensure fair and healthy competition in economic activities, implement competition policies, effectively carrying out competition advocacy. Yes, competition advocacy is a very important aspect of Competition Commission of India, in which they try and spread the knowledge of Competition Act and the competition law all over India through different channels such as seminars, lectures, and for the businesses, for the consumers, for the students, etc. So yeah, the and it is obviously an antitrust watchdog in India, and then yeah, I think more or less these are the functions of Competition Commission of India. Yes.
Okay, sir. So the next question is by Zulfikar.
If Rhea wants to add something,
yeah.
Rhea, if
Sure.
you want
No,
to
I
add.
think it was explained perfectly.
Okay.
So we have the next question by Zulfikar Hussain, who is asking why MRTP Act was replaced to make way for Competition Act 2002. What significant changes it has brought for the companies? I think you all have explained, but again, if you
Yeah,
could
I
address.
have already told that the MRTP Act became redundant at one point of time because it was not able to handle the new aspects of the market after the liberalization, privatization, and globalization. The provisions of MRTP Act was not able to handle such changes in the market. Secondly, they were only related to cease and desist orders, and they were not, they did not have the power to levy any fines on the companies who are indulging in any anti-competitive activities and or any other kind of order apart from cease and desist. They could just request the companies to not do it again, but not put any other, punishment for it, be it pecuniary or there is no other punishment otherwise. So this, for these reasons only, when we were expanding after the Industrial Revolution in 1991, we needed a new law, a comprehensive law to sustain the competition in the market, and hence we shifted from MRTP to competition. What was the second limb of the question?
Second limb was what significant changes it brought for the companies? I think
For the
more or less
companies.
yes, more or less you have covered the entire thing.
Again, the same thing. Yeah. So for the company, it is better that because in MRTP, they were curbing the dominant position, but Competition Act says that they don't have any issues with a company being dominant at a dominant, as Rhea very correctly told, that you can be dominant in the market, but you cannot abuse that dominant position of yours in the market. So that is a major aspect again, which I think it's beneficial for the consumers as well and the consumer. As I told, the fourth objective of the preamble, which says that the CCI is there to protect the interest of the consumers as well as the other market players. So that is an important aspect. Yes.
Okay. Rhea and sir, the next question is what is the main difference between competition law and company law? Someone is asking so.
Okay. So company law is very different from what competition law is. Basically, company law, if you've read, talks about the nitty-gritties of a company, that what should be there in a company, how a company should function, board of directors and auditors, promoters, etc. So they talk about government companies, private companies. In Competition Act, we are talking about the working of these company in the market should be such that it should not be anti-competitive. We only look into the competition aspect of the different companies or different market players functioning in the market as a whole. Anything else, Rhea, if you want to add?
I mean, yeah, Ankit, I agree with Ankit, and I feel like the Competition Act looks at the market conditions in order. It's very welfare driven, right? So it's procedural and substantive, of course, but it's very welfare driven. It looks at the consumers, it looks at the market players in general. Everybody needs to have a level playing field, as I've said. So I think that's one very important reason why the competition law is in force. So, as an entrant, if I want to enter the market, I will, of course, like there are certain procedures under company law, regulations which I need to follow. But am I allowed to enter that market? Can I enter the market? Is it easy for me to enter the market? Are there barriers? Is somebody prohibiting it? So I feel like these are questions which the competition law deals with, answers, regulates, and so on.
Yes, adding to Sir and Rhea, its company law is totally a different aspect, wherein 2013 specifies the rules for a producer company, say a government company, one-person company, and it's totally different where we talk about what should be the MOA and we talk about the incorporation and the articles of association. So competition law is there are points where we deal with the corporate scams where we see a portion of competition law being dealt with in. But again, the two acts are very different. So I thought of adding it as well. So we'll be taking the next question by Rudra Sinha. He is asking what role the CCI has with regard to essential commodities in COVID-19, like masks and sanitizers, when the unfair price is prevailing. Any cognizance by CCI?
So,
Okay, so first of all, Rhea, if you want, first of all, I think the government has removed masks and sanitizer from Essential Commodities Act after July. But when this was added to the Essential Commodities Act and still the market prices were very high, when the COVID situation started, the market prices of masks and sanitizers were very high, unreasonably high, 5 times, 6 times higher than what they were used to be earlier, because there was shortage of the products in the market. So at that point of time, government felt necessary to add them into the Essential Commodities Act. And the government has removed it after 31st of July, if I'm not wrong. They have removed them from the Essential Commodities Act. Secondly, the competition aspect, the CCI's cognizance in this is that CCI has, through a notification, already notified on their website also in public that during this time of COVID, the CCI will be having a very closer look on the functioning of such companies and the way they function in the market, and a cognizance can be taken by the CCI even at a later stage if the CCI finds that during this time there were any anti-competitors, having an adverse effect on competition in the market during this time. If there was anything, they'll take an action upon it. So if you want to read further on it, you can read one of the papers written by me on COVID-19 terrorism in India, competition law challenges. So that might, clear a lot of situation. If you want to read, it is accessible on the internet itself. Yes, Rhea, sorry.
So I think you covered it brilliantly. The one thing is I feel like, I think Ankit covered that as well, that CCI can, I think it has issued advisories. I remember sometime in April saying that, charging exorbitant prices, it can take suo motu cognizance. It's very important to understand that. If it feels that there are certain practices that are being anti-competitive, like charging N95 masks, 3-ply masks, sanitizers, exorbitant prices, it can take suo motu cognizance. And I feel such advisories have been issued by the CCI. Second thing is, it's other regulators across the world are also doing it. They are taking cognizance. So, and it's what
And
the
I think
CCI does
CCI,
also, yeah.
after the global regulators, when decided to do this, after that CCI has come up with a notification in April.
Yeah.
The other regulatory bodies throughout the world, major jurisdictions, came out with a regulatory in the month of March itself. When I wrote the article, you know it better. Yeah. So yes, continue. Sorry.
So we have the next question by the same person. He is asking Rudra Singh, how far can CCI go in expanding its scope of inquiry? Is there any parameters set out by the statute, rules, or judiciary?
Rhea, please.
So the CCI expanding the scope of inquiry, I mean, there are 2-3 aspects. I mean, this is a very, it's highly discussed topic. How much can the director, so, okay. Section 3 and 4, when you're looking at Section 3 and 4, the Director General, the DG conducts the investigation process, right? It will conduct the investigation. How much can it increase? If while during investigation, if it finds that, you are indulging in not just product A, also product B cartelization, so it can, if it's taken suo motu cognizance, it can initiate another suo motu case, right? With respect to combinations, I don't think it's that relevant, because unless it finds that you have hidden some sort of information, because it's a filing to the CCI, right? So combinations I would not touch upon, but when especially cartels, I feel this is very important. If it's taken, however, if a complaint has been filed and the CCI is of the opinion that it's been filed for X product, and there is Y product also involved, it comes out with a 26-1 order. For 26-1 orders for cartels are usually not published. For other cases, they are published. So it does come out with such and such order. And in that order, if it decides prima facie that it wants to exceed the scope, there have been instances where it has. And however, there are certain limits to it. The kind of information that they've got, what is the kind of information that they have got, and it's also that step 1. 26-1 of the order says that the DG can conduct investigation. It's directed the DG to conduct investigation. It hasn't closed its case. 26, once it goes to the DG and the DG conducts an investigation, that's where the real deal happens. That's where the DG, it's conducting its investigation, it will look into, while it's interviewing, it's conducting interviews, depositions, it can find numerous cases. It can go from X to Y to Z. So it's important to have some parameters in place. Usually the Director General will consult the CCI. This is a very procedural aspect of it. However, if the CCI feels that, if it can't exceed the scope in this case, it can issue another case. Nothing bars it. It can take suo motu cognizance. That's very important to understand.
Okay, so the Competition Act also, under Section 32 of the Act, has the extraterritorial jurisdiction in such a in a lot of situations in which, even if anything is affected in the Indian market, the CCI may take cognizance for that also. The CCI has the power of extraterritorial jurisdiction too under Section 32 of the Act. Yes.
And so, Sir and Rhea, before we proceed further, so I would just like to convey to the audience that we have a competition law course, which I think, Rhea, you are one of the faculty. So if you could just talk about the course, how it will help the students and who can pursue this course and what all are there, and do you discuss more on this? What are the portions that you cover? And also for the audience, there is a special code there for through which you can get a 10% discount on Rhea ma'am's course too. So Rhea, over to you about the course.
So This was just an introductory course. I think the course, first thing I'm going to discuss that, the course is going to discuss the procedural, substantive, the kind of, trends that are happening. It's very important to know the Competition Act is a very nascent law in India. So as students, practitioners, people who are pursuing the CA, you're pursuing your CS, you're a new law practitioner. I think it's important to have an understanding of how this law functions. A, it's very interesting. B, it affects the market, right? It affects everything that you will probably be practicing in your law career, or if you're doing CA, CS, right? The law, because it's new, you are learning this course, and the trend the trend would be to learn the course as the law is growing. So you are a part of this learning curve. So I feel that's very important, and that's something that the course will give you. It's 9 years old. Like for example, the merger control regime, 1st June 2011. So I feel you have certain precedents in place and certain more to come. And it's it's very interesting. It teaches you about the economical aspect of the law. So I feel it's going to discuss Section 3, Section 4, Section 5, 6, how the procedure, how the inquiry is done. People asked about how the scope of investigation, how the investigation takes place. What are the different kinds of aspects once you file the combination? How does the review take place? When you're analyzing market shares, for example, how is this analysis done? There are so many. The Supreme Court and the High Court are coming out with new decisions for the past 3-4 years. They've come out with amazing decisions to clarify certain laws. What are these laws? How it had been clarified? How does CCI work with foreign regulators? It has agreements and MOUs with foreign regulators, because this law is a very international law. It's not just contained to your country, right? Ankit just said that, it can take cognizance of foreign transactions or foreign conduct that has an impact on India. So that it's a very global, this law is very global in nature. So it'll teach you about not just laws that are in India, but also US, UK, EU. India derives a major part of its law from the EU competition law. So as a competition person who wants to pursue competition as a career, or just wants to pursue corporate law but wants to have the knowledge of competition law, I feel this is a very broad yet interesting subject to learn and have in your pocket. So these are some aspects which will be, so everything we discussed today and more would be dealt into in greater detail when we are, teaching this subject. Ankit mentioned, each section of Section 3, each subsection can be divided into a separate chapter, right? So everything will be discussed. Each subtopic, each subsection will be discussed. So I think it's going to be a very interesting course.
Thank you so much, Rhea. We have the next question adding to whatever you said correctly. Angana is asking, is there any impact of globalization in competition law? I think Sir and you both have discussed about
I think we have already discussed this aspect.
Yeah. So we'll take up the next question by Zulfikar Hussain, who is asking, two companies manufacturing items that are unique, but due to competition, they are unable to hike price, and suddenly they come with merger only to gain relevant price hike. Will it be challenged in CCI? Should I repeat the question again?
There are only two companies.
There are two companies manufacturing items that are unique, but due to competition, they are unable to hike
this means
price.
that there are two companies who are manufacturing an item which is unique in nature.
Yeah.
Their combinations won't be allowed by the CCI, I feel, because that will, again, as I told you in the very beginning, that we will not be moving towards monopoly, but we'll be moving towards perfect competition. So this move of, combining these two firms will move towards monopoly. So I don't think that if there are only two companies coming out with a unique product, then they could be allowed to merge. I don't feel so. I think they will be stopped from doing so. Yes.
Rhea, if you want to add anything to it.
No, I agree with Ankit. I don't think, I mean, unless you have such economic justifications that they have to, if it's like, if one company is failing, I feel if you have a failing firm defense, then, again, I'm getting into intricacies of it. But if you have a failing firm defense, one company is in losses and the other company wants to acquire it. These are economic justifications that can be offered, but, not having such information on board, I feel it's the prima facie, I would say it might not be allowed.
So we have the next question by Suman. He's asking scope of research in competition law with respect to India for PhD. If you could just advise.
Ankit.
Yes.
Over to you.
So there is a lot of scope when it comes to a research when it comes to research in competition law, because as I told you again in the lecture that this is a very new law for India. It's been only 10 years it has been enforced in India, but in US or in other major jurisdictions, this law is since 1900. So in US, it was introduced in the year 1900. So you see the difference. In 120 years, they have been practicing in this law. So there is a lot of things which we need to research upon according to the change in the market, the change in the market which is happening in India, the coming of e-commerce, the coming of new platform markets, the coming of new companies which are electronic in nature. So these all aspects of competition law, what is the difference between e-commerce and a brick and mortar shop, and how it will affect the Competition Act regime in India. So all these things combined say that there are a lot of aspects in India which can be researched upon. Also, CCI on the other hand hires research associates every year